The next case to come before the court for video oral argument is In Re PC, case 19CA0092M. Each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. When you begin your argument, and if you wish to reserve rebuttal time, just let me know how much, and I will be keeping track of time. I'll do my best to keep you apprised. The arguments are being visually and audibly recorded still to be posted on YouTube. As you know, obviously by the caption of this name, we're not using the names of any minors. So continue with that. And I guess that's it for the preliminaries. We've read your briefs. We are ready to begin when you are. And Ms. Hammersmith, you will be the one to begin.
Good morning, Your Honors. May it please the court. My name is Lauren Hammersmith. I would like to reserve 3 minutes for rebuttal. Your Honors, PC did everything that we would hope a kid in his situation would do. He accepted responsibility for his offense. He successfully completed the treatment program at DYS, and he stayed out of trouble. But the government wanted to punish PC as an adult. So it created a workaround to the Supreme Court's holding in CP. It ignored all of the positive information presented about PC at the sex offender classification hearing, and it allowed unreliable and prejudicial information to be the basis of its decision. And for these reasons, this court must reverse the juvenile court's registration order. The juvenile court did not have statutory authority to classify PC as an adult. For SYOs, the juvenile court is limited to the sentencing options contained in Revised Code Section Chapter 2929, and this does not include adult sex offender registration, because the authority to classify someone as an adult comes from Chapter 2950. It's important to note that when the SYO scheme was being written by the General Assembly specifically provided authority for juvenile courts to classify SYOs under the former Revised Code Section 2152-86. But that section was declared unconstitutional in the Ohio Supreme Court's decision in Re CP. And it's important to note that the reason why they declared it unconstitutional. It was because of the automatic offense-based tier classifications. It was because of the public nature of the classification, and the long periods for which juveniles would have to register. The government cannot come in now and create a workaround to that holding by saying that they can classify PC as an adult, because there is a void in the statute now that 2152-86 no longer exists. The classification authority for juveniles comes from sections 2152-82 through 85, and that classification authority is tied to adjudications. The adult classification authority comes from Chapter 2950-01M, convictions. As I stated before, the reasons for the different classifications authority is because juvenile registration is extremely different than adult registration. Adult registration is automatic and offense-based. It's public. If PC were to be registered as an adult, his information would appear online and would be sent to the public via postcards. If PC were to be required to register as an adult, he would have living restrictions. Specifically, wouldn't be allowed to live near places where children congregate. If PC were to be required to register as an adult, he would have different counties where he was supposed to register. Adults are required to register in the county where they live, the county where they go to school, and the county where they work. And then finally, and I think the most important thing, is adult registrants cannot petition the court for removal. They are going to be what their tier dictates them to be. And the tier 3 is registration for life. So if PC would be required to register as a tier 3, he would be registering until the end of his natural life. Whereas if he were only a juvenile registrant, he could petition the court for removal or declassification or reclassification to a lower tier. To respond to some of the state's arguments in their brief, the state's argument represents a fundamental misunderstanding of what SYOs are. An SYO is a dispositional option that is available to the juvenile court. It is not bind over for sentencing, and therefore the juvenile court is limited by the constraints of 2152.13. The court cannot just give PC any conceivable adult sentence just by the nature of the fact that he was adjudicated an SYO. Specifically, the statute limits other types of adult punishments, such as the death sentence and life without parole. The portion about the SYOs and their sex offender registration did not appear in 2152.13, but that's because it already appeared in 2152.86. And as I stated before, that was found unconstitutional. I would like to now turn to talking about the classification as a juvenile tier 3. And specifically with the admission of the Stranathan report. And that's the thing that kind of kicked off all of these proceedings. The Stranathan report was the very first thing that the court received about PC after it ordered the classification hearing, after PC was released from DYS. This was an extremely prejudicial report. The biggest thing being that the report suggested that PC be chemically castrated. It also diagnosed PC as a pedophile with paraphilic disorders and with voyeuristic disorder. All of those diagnoses were debunked and delegitimized by Dr. Gaisley, who testified at the hearing. Mr. Stranathan was not qualified to give those diagnoses. He was not an expert. And as defense counsel stated in the motion to continue to obtain a second evaluation, Mr. Stranathan was not licensed as a mental health provider in the state of Ohio at all. And third, and most importantly, he wasn't there to answer questions about his report. He was issued a subpoena to come to the hearing, but declined to do so. And as such, he could not answer questions from defense counsel or the state or the court about why he suggested those things. That was the basis, or partially the basis, upon why the juvenile court classified PC as a tier 3. It also stated that it classified PC as a tier 3 because he had not begun sex offender treatment in the community. But PC stated on the record at the hearing that the reason why he hadn't done that yet was because his DYS parole officer had instructed him to wait for the results of the classification hearing. And really, Your Honors, PC did everything that he was supposed to do, like I stated at the outset of this argument. He went to DYS, he did the hard work of dealing with his past and dealing with the behaviors that had been ingrained upon him since he was 4 years old. He admitted to and accepted responsibility for his offense from the get-go. He cooperated with the police. And while the facts of his offense are very serious, those are things that could not change. But what did change from the day of his offense was the fact that he participated in an 18-month-long treatment program where he went through rigorous testing from DYS to determine whether he got it, whether he understood what was happening, whether he was internalizing the treatment program, And by the testimony of Mr. Spahn, his treatment provider at DYS, he did that. And that was numerically provable due to his JSOAP score. And that's outlined in my brief. And so PC did everything that he was supposed to do, but the court classified him as a tier 3, the same as it did on the day that it sentenced him. And contrary to what the state claimed in their brief, this isn't us just disagreeing with the tier 3 classification. It's got to be more than that. If we want our kids to participate in these programs, we want them to take this stuff seriously, we have to recognize that when they do. And really what I see, the state saying is, the court considering everything it had to. It's not just, the court considered everything it had to. It's the court considered all of this stuff and it came to a result that was absurd. Everything that PC presented at the classification hearing showed that he was not the type of kid that should be classified as a tier 3. Unless there are any further questions, we're just respectfully asking that this court reverse the juvenile court's classification and registration order, and I would like to reserve the remainder of my time.
Sorry. There we go. Can you hear me now?
I can hear you.
Thank you. I'm trying to use the correct terminology. When PC was released, give me a minute. Oh, shoot. Hang on, okay. There was some dispute or some question as to him on not starting a treatment right away. And I believe your position was that he was told not to start until after his hearing. Is that correct?
Yes, Your Honor.
Told by who?
His DYS parole officer, Mr. Ngozi.
And did Mr. Ngozi testify at the hearing?
No, he did not.
Okay, that was one question I had. And then the other question was the test you referred to where there's a drastic change in the score that would indicate some improvement. Was there testimony about that during the hearing?
Yes, Your Honor, by both Mr. Spahn and Dr. Gaisley. Both of those individuals, Mr. Spahn was the DYS treatment coordinator, and Dr. Gaisley was an independent expert that my office retained to evaluate PC. Mr. Spahn evaluated PC several times over the course of his time at DYS using the JSOAP tool. It stands for Juvenile Sex Offender Assessment Protocol. And what DYS uses that tool for is to determine whether a child is internalizing the treatment concepts that they learn at DYS. So, and this is outlined in my brief more specifically, but essentially what they're doing is they're looking at the intervention score. There's 4 scales that the DYS or that the JSOAP has. The top 2 scales, and I apologize, I'm forgetting the exact names of the scales at the moment, but those ask questions of a child about the nature of their offense and about their past history. So those 2 scales are never going to change because they're static scores. The third scale, the intervention scale, is a dynamic scale, and that will change over time. Either it can go up or it can go down. And if it goes down, how DYS interprets that is that a child's risk is being lowered over time and that they're understanding their treatment concepts, they're showing guilt, they're showing remorse, and acceptance of their offending cycle. Dr. Gaisley also performed another JSOAP assessment after PC had been released from DYS, and his score went down even further. So I know that the court stated in its entry that there was no explanation for why the score had gone down over time, but that was testified to by Mr. Spahn at the classification hearing, and those sites are in my brief.
All right, thank you. Mr. Bellucci.
Good morning, Your Honors. Thank you. May it please the court, I'm Vince Vellucci with the Medina County Prosecutor's Office on behalf of the state of Ohio, the appellee. I will start with the first assignment of error, where PC is arguing that the trial court, the juvenile court, erred in classifying him as a adult tier 3 sex offender registrant in the adult portion of his serious youthful offender sentence. First, I think we need to be clear that the juvenile court didn't actually impose an adult tier 3 registration. It did that only as part of PC's stayed adult sentence. That's exactly what SYO is. That's the entire point of serious youthful offender. There's a carrot and there's a stick. The adult part of the sentence remains stayed unless the juvenile doesn't complete his juvenile sentence. And it's not an easy thing to invoke the adult portion of the sentence. There's a whole process that has to take place that I know this court has dealt with that before, in which that actually occurred, and that's a whole other issue. But I'm not sure if PC is trying to attack the entire serious youthful offender framework or what exactly. But the fact is that's what the law is. And if PC or his counsel think that the SYO laws should be different, they need to take that up with the General Assembly. This court did consider and reject that exact argument that they're making in this case in the In Re DJ case. That's 2018 Ohio 569. In fact, no court in Ohio has said that an SYO sentence can't include adult sex offender registration. That's part of the stayed adult sentence. The CP case that the public defender is citing has nothing to do with this case. It's a completely different issue. The CP case invalidated public registry qualified juvenile offender registration. That's a mouthful, but that is a completely different thing. We are not dealing with that in this case. This is not that. So to cite CP, it just has nothing to do with this case. And in terms of statutorily, I point out in my brief, I think this is the most important thing actually, 2152-191. So 2152-191 actually expressly states that Chapter 2950 does apply to juveniles who are adjudicated delinquent of a sex crime. So that same framework that applies to adults, that Chapter 2950 does apply specifically by statute to juveniles who are adjudicated delinquent of a sex crime. So I think it's right there in black and white as well, that this is how it works. This is valid. I'll move to the second assignment of error, which is that the trial court abused its discretion by admitting the Summit Psychological Report, Mr. Stranathan's report, into evidence when he did not actually attend the classification hearing. This court and also the Supreme Court of Ohio have long held that the rules of evidence do not apply at a sex offender classification hearing. They're part of sentencing. We know, of course, in the evidence rules, 101C, that's one of the exceptions. So it specifically lays out that the evidence rules don't apply in that situation. The seminal Supreme Court of Ohio case that I cite is the Cook case, 83 Ohio State 3D 404. And this court has also specifically held, I cite the Lawler case, that a trial judge can rely on reliable hearsay like pre-sentence investigation reports, which is essentially what this was. Additionally, if you look at the factors that the juvenile court has to consider when classifying a juvenile, you look at 215283D. So D6 actually requires trial courts to consider any follow-up professional assessment of the child in making its classification decision. So not only was it not improper for the juvenile court to consider Mr. Stranathan's report, it had to consider his report by statute. It would have been error not to consider Mr. Stranathan's report.
Well, Mr. Vigliucci, is there a time when you have to consider whether you should consider the report? And that was really a horrible question. But, you know, I've been at this for a long time, and I cannot swear to it, but in years, not to age myself, but as a judge and as a prosecutor, I'm not sure I can ever remember reading a report that recommended chemical castration. You know, kind of raises your eyebrows, and you know, certainly the judge didn't mention that in his entry, but you know, is it mandatory that he considers it, or do you think you might, you know, wants to question that person in court? I mean, you know, it sounds, you know, you say yes, he has to consider it. Does he?
I think so. There's a broad range of things you have to consider under that statute, and that's not even a non-exhaustive list. Just anything, basically, any relevant information. And I think something from a professional, from Summit Psychological, a report that's been done, certainly is something that needs to be considered. Now, do you have to consider every single thing that the person says? I don't think so necessarily, but you got to at least look at the report and consider it, I think, as a whole. And I think it's important to note that not only was the judge considering this report, he was actually considering testimony of two witnesses that PC presented at the classification hearing that was mentioned, Mr. Spahn and Dr. Gasly. And I think the trial court, as you mentioned, did not mention that chemical castration part in his entry, but the judge did mention a whole lot of other things in a 14-page entry. This is a very thorough explanation that the judge went into, explaining why he made the tier 3 decision. So I'll just go into that now in terms of the juvenile tier 3 decision. I note in my brief that several Ohio appellate districts have noted that you don't actually have to explicitly announce findings on every factor of 215283D. So you don't have to go through and say, I find this on this factor and this on this factor. In fact, the juvenile courts are not required to express their reasons for making their classification decision at all. And we know that when you talk about, and that statute also, that 215283 incorporates 29, 29, 11, and 12, those classic, sentencing statutes, seriousness and recidivism factors. We know that when it comes to those statutes, that the case law says even when nothing is put on the record, it's presumed the trial court gave those statutes the proper consideration.
Remind me of what the court found in light of what Ms. Hammersmith said, that PC completed a rigorous sex offender treatment program while in DYS. He got his GED. He was working upon release, didn't get into any other trouble, showed remorse. How did the court counterbalance that?
Well, I think so. PC got out of DYS on August 1st, 2019. And his classification, his reclassification, I should say, after the first case came back down, didn't happen until November 21st, 2019. So there's a gap there of a good 3-4 months, almost 4 months, I guess, when he gets out and doesn't seek any kind of treatment at all. Now, during that time, he was not officially classified as a sex offender yet, but obviously he's been adjudicated of this very serious, 6 counts of rape, 17-year-old. The state of Ohio tried to bind him over and try him as an adult. This is how serious this case is. This is a 17-year-old at least 6 times raping his 4-year-old niece, and he's got an SYO hanging over his head. And for 4 months, he gets out of DYS and doesn't do anything whatsoever to seek to continue his sex offender treatment. So he's out there on his own for 4 months with no treatment. And to the judge, and I think this was more than reasonable, took that as he's not taking his rehabilitation as seriously as he could be, because everyone agreed, his own people, Mr. Stranathan, etc., everybody agreed that PC needed ongoing, intensive sex offender treatment, and he was getting nothing for 4 months. He didn't follow up. Now the idea that his parole officer told him not to, I don't think that's found anywhere in the record. As Judge Callahan mentioned, he didn't testify, so I don't think we have any actual evidence of that this court can consider. But contrary to what PC is saying, the juvenile court, in its, as I mentioned, 14-page entry, considered at length, I think, the opinions of the 2 people who testified in favor of PC, Mr. Spahn and Mr. Gasly. The juvenile court actually noted Dr. Gasly's opinion, his evaluation, where he said that PC's sexual crimes were just his way of relieving sadness and depression. And the state of Ohio, I think, believes that the juvenile court correctly noted that should leave everyone concerned. So the idea that that report somehow is in his favor, I don't agree with that. And as I mentioned, the juvenile court also noted the horrific facts of this case, which I've noted. It was also revealed during the case that PC actually had an ongoing incestuous relationship with his older sister for years. So that actually came out during the case, and the judge was aware of that as well. And again, the Summit Psych report, Mr. Stranathan's report, indicated that PC was in fact a high risk for future offending.
He was subpoenaed to testify, by the way.
I believe I believe he was, and there was some some reason he was not able to attend, Your Honor. I'm not sure. I don't believe that appears in the record. I'm not 100% sure on that, but
did anybody move to continue the hearing based on that?
I do not believe so. And I think the idea was that we have this report that could be considered, and there were also these two other witnesses for PC that testified, a gentleman from DYS, of course, and the other psychologist.
Remind me, was there an objection to the report at the hearing?
I believe there was, yes, and it was admitted over the objection. But I think PC does just simply disagree with the juvenile court's classification, which I think was well reasoned, well supported. I'm not sure what else the juvenile court could have done in terms of writing out a decision to explain everything, and I don't think that means that the court was viewing PC's case through an adultified lens. As I said, we were asking the juvenile court to bind this case over and to try PC as an adult, and the court refused to do that and denied our motion to do that. I think it was not viewing this case at all through an adultified lens. He classified, the judge classified PC as an adult sex offender only as part of the SYO stayed sentence. So he didn't actually classify him. He classified him and stayed.
I find it harder to get a word in on Zoom, but all right. With that, your time is up. Thank you, Mr. Vellucci. Ms. Hammersmith, probably due to my question, you went into your rebuttal time. I tacked a little more on it. You got about 2 minutes left.
Your Honor, just a few quick points. To answer Judge Teodosio's question, Mr. Stranathan was subpoenaed at the original hearing. The reasons why he did not appear at that hearing were not on the record as a part of this record, but defense counsel, which was me, moved to continue the hearing and obtain a second evaluation, which was from Dr. Gaisley. That is in the record. Second, regarding the reason why PC did not participate in treatment from the time that he was released from DYS, defense counsel, again, which was me, stated that on the record in the closing arguments during the sex offender classification hearing. So that's where that is in the record.
But that's not it.
I'm sorry?
That's not evidence, correct?
No, and this issue was discussed off the record, so that the bulk of that information was not in the record, but that, defense counsel did have conversations with the parole officer, and in addition to that, regardless of why PC did not engage in treatment, he didn't get in any trouble from the time that he was released from DYS to 2 months later. He had no parole violations filed, no new charges, no complaints at all from his dad, who testified at the hearing, and his parole officer. And so I think that speaks to what was going through PC's mind and what he was undertaking and the seriousness with which he took his treatment. But I want to address a couple of points from the first assignment of error. First, regarding 2152-191, that section applies certain sections of Chapter 2950 to juvenile registrants. Chapter 2950 is a vast chapter that includes both definitional sections and sections that authorize the courts to take action. And I'm certainly, I know that the state and this court can differentiate between the two. Revised Code Chapter 2152-191 does not provide any kind of authority for a juvenile court to impose an adult classification on an SYO. There's a gap left in the code because CP held that the classification statute for SYOs is now gone. So I think it's not correct to say that CP doesn't apply because CP shows us that there's the gap. There's been nothing filled in, and the juvenile court and the government can't create a workaround when that statutory authority does not exist.
Counsel, you're well past your time, but thank
Okay,
you.
thank you.
Does anyone have any questions?
I have one question.
Because I have one too, so go ahead.
Are you asking us to hold that when a juvenile court imposes a SYO, serious youthful offender sentence, on a rape case, that the adult registration, which is mandatory, right, under the law, is not appropriate? Is that the rule you want us to set in this case?
It's more than just not appropriate, it's not authorized. There is nothing in the code that authorizes juvenile courts to impose adult sex offender classifications on SYOs.
Okay, thank you.
And then I guess I'm going back. I'm going to turn the table on the chemical castration that I was so outraged on with Mr. Bellucci. It's basically, it sounds so nasty. It was a recommendation basically that he take a drug. Was that so outrageous?
Yes, Your Honor. This is a 17-year-old kid. And as I explained in my brief, the entire...
Hang on a second. And the victim in this case was a 4-year-old child.
Yes. Juvenile sex offenders are viewed differently under Ohio's law than adults who commit those same offenses. PC presented a lot of information at his classification hearing about his entire life leading up to the moment where he committed and accepted responsibility for those offenses.
Okay.
I'm not here saying that those are not very serious and bad things. I'm saying when Mr. Stranathan put this unconstitutional and frankly barbaric suggestion in his report and then failed to answer for that, it tainted the entire report. And I'm not sure how you can parse out the things that he's saying, legitimate things, I guess, or not legitimate things. That to me says the entire report is in question. And furthermore, the fact that he wouldn't come to the hearing to answer for those diagnoses and that suggestion that he be chemically castrated. I mean, that is very concerning. And while the rules of evidence would not apply at this hearing, the court certainly has a very vested interest in receiving credible and reliable information. And I'm not sure how a report that suggests that could be, for a 17-year-old, could be credible or reliable.
All right. Thank you. I understand your point. Thank you. All right. Thank you both for a very good argument. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides and posted on our website as well as that of the Supreme Court. Have a great day.
Thank you, Your Honor.
Thank you, Your Honor.